be as provided for in the second schedule, but subject thereto, the Commission may regulate its own procedure. Paragraph 5 to 7 of the second schedule, prior to amendments introduced through the Election Laws Amendment Act number 34 of 2017, provided, and I have reproduced those provisions there, I will not read them, and then I say that through Election Laws Amendment Act 34, paragraphs 5 and 7 of the second schedule are repealed and replaced with those provisions. Paragraph 8, which was not affected, of the second schedule, provided that subject to paragraph 5, no proceedings of the Commission shall be invalid by reason only of a vacancy among the members thereof. Those amendments were successfully challenged and declared unconstitutional by the High Court in Katiba Institute case, and I have cited passages from the judgment of Justice Muita, which are there. IBC contends that as paragraphs 5 and 7, as previously enacted, had been repealed, the declaration by the High Court invalidating the amendments did not revive the repealed provisions. It was urged that by relying on provisions of paragraphs 5 and 7 of the second schedule, as they existed prior to the amending provisions being declared unconstitutional, the court relied on non-existent provisions, and therefore Article 250, which sets the minimum at 3, applied. Respectfully, I do not understand the decision of the Supreme Court in the case of Mary Wambui, which was cited as supporting the proposition put forth by IBC. If I understand the argument correctly, it is that the effect of the declaration of unconstitutionality by the High Court of the provisions of the Election Laws Amendment Act number 34 that had sought to amend paragraphs 5 and 7 of the schedule is that the schedule is now silent on quorum. That there is in effect no longer a provision at all in the schedule on quorum, and therefore recourse must be had to Article 250. I am not entirely persuaded by that argument. Article 250 of the Constitution does not, with respect, address the question of quorum of the Commission. It is a provision on composition. It sets the minimum number of persons who must make up the Commission. Quorum speaks to the minimum number of commissioners that must be present to make a binding decision. It speaks to the number of commissioners who, when duly assembled, are legally competent to transact the business of the Commission. As defined in Black's Law Dictionary, it is the minimum number of members who must be present for a deliberative assembly to legally transact business. Article 250 of the Constitution cannot therefore fill the gap which the IBC says was created by the declaration of unconstitutionality of the provisions that had sought to amend paragraphs 5 and 7 of the second schedule. In the case of Mary Wambui, the Supreme Court in paragraph 87 of the judgment expressed as follows: however, while we have pronounced ourselves on the issue of invalidity of section 76(1) of the Elections Act, in line with the Constitution, this court is not precluded from considering the application of the principles of retroactivity or proactivity on a case-to-case basis. I then look at the decisions they cited there, including the decision by Justice Kriegler in the South African case of Sears Moyes, and I then go on to say that the decision of the High Court in the case of Katiba Institute was silent on the effective date of the declaration of unconstitutionality. Based on the decision of the Supreme Court, I take the view that the default position is that the declaration of unconstitutionality related back to when the unconstitutional provisions were enacted, with the result, in my respective view, that the status quo ante was restored. Therefore, the requirement of quorum of 5 applies. I am therefore in agreement with the High Court that when it pronounced in the judgment that IBC Act categorically places the quorum of IBC for purposes of transacting business at 5 commissioners, and that IBC did not have that quorum at the time it made the consequential decision related to the Constitution of Kenya Amendment Bill. IBC also contended that the impugned decision of the High Court runs afoul of a subsisting decision in rem in a constitutional matter, in the case of Isaiah B. Watt, which has been extensively cited. And I'll cut through and just say I am conscious that this court is not presently sitting on appeal from the judgment of Isaiah B. Watt. However, it seems to me that quite apart from reading into the text of paragraph 5 of the schedule, the words policy decisions, and apart from mixing up composition with quorum, the learned judge appears to have either overlooked or infused statutory provisions with what she considered to be common sense when she stated, quote, "My take is that the issue of quorum, apart from being a matter provided for under the statute, is also a matter of common sense and construction, depending on the total number of commissioners." And then I have the rest of the passage, and then I say, further, in making that pronouncement, the learned judge does not appear to have considered the provisions of paragraph 8 of the second schedule, which provides, subject to paragraph 5, no proceedings of the commission shall be invalid by reason only of a vacancy among the members thereof. Under that provision, the requirement under paragraph 5 is overriding. The pronouncement by the judge in the above cited passage appears, therefore, to be an abrogation of a statutory provision, and to that extent is per incuriam. Consequently, the High Court in the present case was entitled, for that reason, among other reasons the court gave, to depart from it. Moreover, the statutory commands in the IBC Act, if heeded and complied with, would have ensured that the number of commissioners would not have fallen below the number required to form a quorum. For those reasons, the complaint regarding the findings by the High Court as to quorum have no merit. I then move on to the issue of continuous voter registration, and I think I'll just say what I concluded. The High Court cannot therefore be faulted for having concluded, as it did, that there was no evidence that IEBC had discharged its obligation of continuous voter registration. I would therefore not interfere with the decision of the High Court. The last aspect I think I'll look at, separate and distinct referendum questions. On that I say, in my reading of those provisions, that is of the Constitution, it is the bill in which an amendment proposal is contained that is submitted to the people to vote on in the referendum by indicating whether they agree or disagree with the amendment proposal, much in the same way as the members of the county assemblies and members of the Houses of Parliament would have signified their approval or disapproval of the amendment process in the draft bill. It seems to me, therefore, that under Article 257.10 of the Constitution, as read with other provisions in that article, what is envisaged of the voter at the referendum is for the voter to make a choice to ratify or not to ratify, to approve or not to approve the amendment proposal in the draft bill. However, that choice, in my view, is rendered nugatory, inoperative, and consequential if the voter is called upon to vote on an omnibus draft bill that contains a raft of numerous, diverse, and unrelated proposed amendments to the Constitution, in this case over 70 proposals, that cut across the entire spectrum of the Constitution. And I cite the passage there from the High Court decision entitled Alila. The argument made for the respondents on the principle of unity of content or single subject matter, that constitutional amendment through a referendum should deal only with one main issue, is one I find most attractive and persuasive. It was argued that under that principle, the proposed amendment should deal with one subject only to allow the voter to form and express their opinion freely and genuinely. In other words, if a proposed constitutional amendment includes several substantive questions, the voter may not have a free choice, that each proposed constitutional amendment ought to secure adoption on its own merits, not on the merits of other different proposals to which it is attached, and that there must be an intrinsic connection between the various parts of each question to put to the vote in order to guarantee freedom of suffrage, and the voter must not be expected to accept or reject as a whole provisions without an intrinsic link between them. I would venture to suggest that what is envisaged under Article 257 is an amendment bill on single thematic topic to which the provisions in the draft bill must relate. For instance, a bill proposing amendments to the provisions on land under Part 1 of the Chapter 5 of the Constitution would, in my view, be incongruous with proposals in the same bill for amendment of the unrelated matters of the Office of Parliament under Part 3 of Chapter 8 of the Constitution. Ultimately, it seems to me that to put a single binary question or multiple questions is a matter to be informed by the nature of the amendment proposed. It may well be that certain proposed amendments may require separate and distinct referendum questions to be framed. What, in my view, Article 257(10) of the Constitution does not contemplate is the submission to the people in a referendum of an omnibus amendment bill, a hodgepodge of an amendment bill such as the Constitution Amendment Bill in this case. The argument that it would be impractical on account of logistical difficulties to formulate over 70 separate and distinct questions is perhaps more the reason that an omnibus amendment bill should never be entertained. Then I move on to constituency apportionment, and I think I have agreed with the lead judgment of the President, and so I will not deal with that. And then I deal with the matters touching on the President. Under this head, the issues are whether the President's right to fair hearing was violated, whether the President enjoys absolute immunity under the Constitution, whether the High Court was right in declaring that the occupier of the office of the President is liable to being sued in his personal capacity during his tenure of office. And I think I'll just go to the conclusions, which are as follows. Article 51 of the Constitution provides that every person has the right to have any dispute that can be resolved by application of law, decided in a fair and public hearing before a court, or if appropriate, another independent and impartial tribunal. Therein is the long-standing principle of natural justice that traces back to Ridge versus Baldwin, and also the case of Onyango, Olo Onyango versus Attorney General. I have also cited it there. The critical question, which is a matter of fact, is whether the President was firstly served with a petition 426 in which he was named as the first respondent, and secondly, whether he was served with notice.
Anaitwa Stephen Gatembu, jaji wa mahakama ya rufaa humu nchini, ambapo anatoa hoja zake kwa nini anapinga ama anakubaliana ama anapendekeza BBI izidi kusonga mbele, huku swala la saini za IEBC ambazo zilikuwa zimekusanywa kwa sababu ya mchakato huu mzima wa mabadiliko ya katiba, akisema kuwa IEBC ilikuwa na idadi kamili ya makamishna ambao walihitajika. Na mtazamaji, kuna majaji ambao vile vile walizungumza hapo awali, Fatuma Sichale akiwa pia ni jaji wa pili ambaye alitoa hoja zake, akisema kuwa kuna mgawanyiko kuhusiana na kanuni au mafundisho ya historia ya kisheria, na wasomi mbalimbali wenyewe hawajaweza kukubaliana ni ipi inayofaa kutumiwa. Na vile vile Sichale amedokeza kuwa iwapo taifa linataka kukua kikatiba, lazima kuwe na nafasi ya mabadiliko ambayo imependekezwa. Manake mwaka wa 2010 mabadiliko haya yaliweza kufanywa. Kumekuwa na gumzo pia ambayo imeleta utata sana kuhusiana na kanuni za kimsingi ambazo haziwezi kubadilishwa kamwe, au kwa kimombo ambayo wamezingatia sana. Kila jaji akiingia kutoa hoja zake anazungumzia swala la basic structure, ambapo kuna mataifa mbalimbali kama vile Pakistan, Malaysia, Kenya ikiwemo Uganda, India zimetajwa pakubwa, ambapo baadhi kabla ya Kenya kubadilisha katiba yake mwaka wa 2010 kuna baadhi ya vipengee ambavyo havingeweza kubadilishwa, lakini kutokana na mabadiliko ambayo yalifanywa miaka 11 ambayo ilipita, inamaanisha kuwa sasa hivi katiba ya Kenya inaweza kubadilishwa. Nafasi ya rais katika mchakato wa BBI kulingana na kipengee cha 131, Sichale amesema kuwa majukumu ya rais hapo kidogo aliweza kupita mpaka wake. Na sasa hivi mtazamaji, hii ni baadhi tu ya mchakato wa BBI. Je, itazidi kusonga mbele ama itazamishwa na mahakama ya rufaa humu nchini? Majaji 7 wanazidi kuamua. Kwa sasa hivi tuende kwenye mapumziko. lakini kwa sababu ambazo hatungeweza kuepuka, mtazamaji, tunaomba tukatize majaji hao 7 na taarifa hiyo mbashara tuweze kukuletea diko viwanjani. Katika upande wa pili, mtazamaji, mwenzangu Cedric Koronje tayari anasema kuwa niweze kumaliza hapa, tuvuke pale tuguzie spoti, nini ambacho kinajiri. Mimi wako Cliff Ndubi na Michael Maithia ndiye mkalimani wetu mchana wa leo. Mtazamaji, usibanduke.